Ladies and gentlemen, panelists, and Professor Goda, a very good afternoon for all of you. I work for CPA Global Corporation, and I work in a dedicated Microsoft team. We work only with Microsoft client, and I've been in this profile for the past 8 years. My primary responsibility is, setting the strategy for the team. Okay, and being a knowledge officer and involving myself in pilot projects and discussions with the client, which is Microsoft. And my basic background is I'm an electrical and computer engineer, and I've been in IP space for 8 years. Before being in IP space, I was playing various roles. I was a professor. I was into R&D, and I was into software development also. I can say, accidentally stumbled into IT space, and I like this role, so here I am. The topics, as you see, it's US prosecution and filing issues. It's a vast ocean. I mean, we can keep on talking it for days together, and we won't reach any conclusion. But here, what I'm going to do here is I'm going to touch up a few issues which is basically significant for us, and hopefully, we can understand better about this. You can see the concept here called carpet bombing versus cherry picking. Any prosecution strategy, if you're a corporation or if you're a company, you can kind of accommodate your strategy into either carpet bombing or cherry picking. Let's expand on this. So what happens in carpet bombing is that a certain technology area is fast evolving. Maybe 1 or 2 years before the touch space, the touch computer space, and the mobile space. So a lot of companies, a lot of innovations are happening here. So the best time in this scenario, you don't have any time to think or to act. You just tell your inventors and R&D department, you invent any damn thing, I want to file it. Okay, it'll be like you're doing it in a hurry. I know there are a lot of issues involved in which it's a high cost strategy, you have to spend a lot, but in order for you to be competitive, you have to occupy those spaces, the innovation, and so you can't kind of wait and watch and see which is the best invention and file it. So, at this point of time, we build the heft, and then we go ahead and capture these white spaces. And another place we can look for is detectability is also an issue. Like if my invention is kind of embedded inside a chip which is not detectable, so you can't detect infringement. So maybe it's not of much value. But the same thing in the user interface space where things are readily visible and easily detectable. There also you want to rush and just carpet bomb the space and get whatever inventions you want, just go ahead and file it. Okay, and so what happens later on? It is a huge cost. It's not only a filing cost. Okay, there is a prosecution cost, and it's always possible that you may not get a very broad claims, you may get some narrow claims here. And also, even if the patent is granted, we don't know how useful it will be in the licensing time, or what will happen during the maintenance phase. Again, the maintenance fees is very high. So at that time, you can take a measured approach, try to do some check competitors if they're doing the same thing, and try to drop those cases. But it makes a bit of sense that in these cases you carpet bomb the space and occupy get as many patents as you want. Okay. Now coming to cherry picking. So I think it is generally, the previous strategy might look a bit mad strategy. This seems to be a more saner strategy. In this, what you do, it's the usual thing most of the people do is you get your invention disclosure from inventors, perform a thorough prior art search. I would highly recommend this, and if possible, try to search again once once you have a certain initial set of claims. So you will get a better patent that way. Okay, so there should be a good coordination between the prior art search and the drafter to get the best best scope for your claims. And in this case, what we can do is, at every prosecution stage, it makes sense before drafting your office action response. See if any competitors are there. Are they doing what this invention is? And try to direct your prosecution and try to direct your claims to occupy those places. So, and also, I mean, you can also take filing, continuation patent decisions at any point of the time. Okay, and this is a sane strategy. So the cost controls are in place, and you're not wasting a lot of money and resources and all this stuff. And also, I'm sure it won't put any pressures later on after grant with respect to maintenance fees and so on. But however, in the real world, you don't have companies who do only cherry picking or who do only carpet bombing. It's a kind of a hybrid strategy. I mean, mostly your company or your clients might be, for some places they'll be carpet bombing, and for some aspects they'll be cherry picking. So we saw in which cases, like one example I told you was, if the art area is like fast developing, then they will go ahead and do carpet bombing, and otherwise they do the normal strategy of cherry picking. Okay, the next problem we face when we prosecute in US is, or we basically are dealing with the US market, is the NPE problem. I think by this time you must have heard what NPE is. They are the non-practicing entities. There are some more pejorative names. One name might be the troll, but I would rather refrain from using the word, because even a single inventor who has invented something in a garage and filed a patent, and if he's asserting his patent on others, maybe he should not be called as a troll. One of my friend, he came up with a better definition, for who a troll is, but it's not an official definition. He says the people who game the patent system for their gain, they might be called trolls. But right now I'll stick with T word instead of trolls. So I'm not offending people out here. So what happens with trolls is, you have a portfolio of patents. Fine. I mean, you're a corporation or you're a startup or something. You have a portfolio of patents, and you're going in the market. You're selling your product and licensing whatever. But suddenly you are faced. If let's say you have a tangle with a corporation of equal size or something, then typically what happens is, okay, I have these patents. You have those. Let's exchange it. Let's cross-license. Okay, so problem solved. Things are civilized. Business is as usual. But the problem we have is we have non-practicing entities. So you have patents, but you don't have a target because they don't have a product. So what do you do with them? The only option till now was settle. Okay, fine. Pay me some X million dollars, and provide me a license for using this. So what was this leading to is what I call the cycle of gorging. Okay, the trolls, the T word, what they do, they settle with you once, they collect millions, they'll obtain more patents, okay, and they will get more patents, and they'll come after you again. There's no end for this. So what do we do now in this case? Okay, we have, the best way, is never, a person is gaming a system, never deal with them or never settle with them, fight to the finish. That strategy might work but it might work with the larger corporations who have deep pockets. They can spend millions on litigation, and they can probably, bankrupt the T word person. But it may not work for everyone. What I'm going to present is some of the post-grant options, and we'll explore a pre-grant option which is available now, how to deal with this T-word problem. Okay. So we have various post-grant options for us now in US jurisdiction. We have something called a post-grant review. And it has some time limitations. It has some limitations in that it has to be done within 9 months, and there is a covered business method review along with this. And we have inter partes review, which you got after the new law change, which is the AIA law, and which is, I would say, kind of reconstituted inter partes re-exam. But however, it is limited only to the prior art based rejection, which is anticipation obviousness. You can't use 101, which is patentable subject matter, or 112, which is enablement and written description against this. And you have a simple re-examination, which is done ex parte. We see that in ex parte re-examination, once you start the process, you can't participate. As a third party, you can't participate in that. But however, in inter partes review, you can be an active participant. But the problem here is you have to, if you're a part, you have to show yourself as a party of interest. You can't do it anonymously, or you can't do it that way. And whatever result comes out of an inter partes review with the USPTO, USPTO, you are bound by that, in the sense that you can't raise the same issue in a court. Okay? And this is expensive, which costs anywhere between $9,000 to $18,000 only in fees, only in USPTO fees. I'm not talking about attorneys. And it is subject to higher standard because the patent is already granted. Okay, so it is tough to invalidate a granted patent rather than stopping a patent from getting issued. So we have a new kind of option with USPTO. This is a part of the new law, which is the AIA, and it just costs only $180. That is, you can give prior art, and you can tell the examiner why this prior art, why this prior art, negates that the application under prosecution. And since it is during prosecution, this has a lower standard in the sense, the examiner just has to show broadest reasonable interpretation rather than, substantial, invalidity standard. The NPs, typically what they do is, they publish, but they don't show that the patent belongs to them. So in CPA, we have worked out some assignee prediction algorithms where, based on the location, based on the attorneys, we can, to a high degree of confidence, predict who this NP is and directly target them with this pre-grant prior art publication. The last issue I'm going to discuss is the information disclosure statement, which is, I would say, kind of unique to US jurisdiction, where a prosecuting attorney and anyone involved in the patenting side, they have a duty to disclose whatever information they have. So this, if it is not done properly during litigation, it comes to haunt them, and it's declared inequitable conduct. And what happens is the patent may not be enforceable. So there is a bit of respite out there. After Terrasens versus Becton case, previously you had an intent prong to show that this prosecutor had an intent to suppress, and there is a but for materiality, that is, if this invention, if this prior art is available to the examiner wouldn't have allowed it. So these two things were put in a sliding scale. So if this was high, the court used to ignore the other, and so on. But now with Terrasens and Becton, both has to be shown. So there is a kind of respite to the prosecutors here. And you have one more kind of option here is, after AIA, we got something called a supplemental examination. This can be applied after grant also, in the sense that you kind of forgot to cite some prior art or something, and the patent is granted. You can still, use the, take the prior art and, show that in this supplemental examination, and this prior art goes into record. If the prior art has, raise some substantial questions of patentability, then the examiner might order a re-exam or something. But otherwise, this stays in the record, and cleanly you see here, it kind of negates the inequitable conduct issue here. So it's almost like a holy water. Any sins you committed during prosecution gets cleansed by this. The fees is a little bit on the higher side, but it's definitely worth it. If instead of it's definitely better than having the prosecuting attorney being called before during the litigation and being questioned why you've done that. Okay, thanks for listening.
Yeah, thank you so much.